Now that they had the vote, women had to change state and federal laws on issues ranging from equal pay to reproductive rights, property rights to pregnancy leave. Only 3 years after the 19th Amendment was ratified, Alice Paul wrote and proposed a new amendment to the Constitution. This time, it was the Equal Rights Amendment.
The Equal Rights Amendment is a provision that says equality of rights shall not be denied or abridged on account of sex.
It was to make explicit that among our most basic values is the equal citizenship stature of men and women.
Though it was first introduced in the 1920s, the ERA didn't gain widespread support until the 1960s, when the women's rights movement emerged.
The campaign was in every state, and eventually they got Congress to pass an Equal Rights Amendment. But there was a great ratification struggle in the states, and there was a movement to stop it, headed by a woman named Phyllis Schlafly. And she figured out that she only needed a small number of states to stop them.
This is the most unfair, illegal, unequal, and discriminatory bill ever proposed by the Congress.
I think it was owing to a single person that the Equal Rights Amendment was defeated, and that woman was Phyllis Schlafly.
The fight for ratification of the Equal Rights Amendment ended yesterday after 10 years.
The deadline passed before the ERA was ratified. The Equal Rights Amendment failed to become law. But in 1971, a young lawyer brought the Equal Protection Clause of the 14th Amendment full circle. In Reed v. Reed, the court considered whether an Idaho inheritance law giving preference to men violated the Equal Protection Clause. That young lawyer who wrote the brief arguing that it did was Ruth Bader Ginsburg.
The climate of the era was on the side of change. And Reed v. Reed was, I think, an ideal turning point case.
Nearly a century after the court had denied women equal rights in Minor v. Happersett, a unanimous court in Reed ruled for the first time that the Equal Protection Clause of the 14th Amendment protects equal rights for women.
I like to think of the 19th Amendment as improving the 14th Amendment. The 19th Amendment eliminated the idea that the vote is something reserved to men, and therefore the equal protection guarantee should work. Women should be considered full persons under the 14th Amendment.
Today, women turn out to vote in higher numbers than men in every single election. Women aren't yet paid equally, but they have a say in laws that affect their rights because they have the right to vote.
Voting has personal meaning to people because if you are a citizen, voting is the principal way that you express yourself as a participant in the body politic.
Voting defines one's citizenship. People see the right to vote and have always seen the right to vote as central to citizenship in a democracy because that's how you defend your rights. Nothing comes easy. Democracy has to be fought for.
A woman has a right to vote to choose the officials that are going to govern her life.
We remember Susan B. Anthony and Elizabeth Cady Stanton because we are standing on their shoulders. They were promoting a message, votes for women, when society was not yet prepared to listen. Women should be considered full persons. Today, we recognize that it's unthinkable to deny any citizen the right to participate in her government through exercising the right to vote.